Jocelyn Stewart, also known as the Messy Military Lawyer on TikTok, Instagram, and even here on YouTube. My website is www.ucmj-defender.com. If you had to suffer through the Administrative Separation Board process or the Board of Inquiry process as an officer and you did not receive a favorable outcome, maybe you didn't find us soon enough, maybe you didn't avail yourself because you couldn't afford it at the time to have private civilian representation. Do not forego the opportunity to submit matters to the convening authority, the show cause authority, before they try to approve your separation. Most people do not avail themselves of the right that they have to respond and to provide a memorandum of deficiencies regarding the board itself. Even if we did not represent you at the board, and particularly if we didn't represent you at the board, you should obtain private counsel to take a fine-tooth comb over that board's process. We highlight any irregularities. The first part of our Memorandum of Deficiencies addresses whether or not there were any legal errors. Now, that could be very simple as if there were challenges for cause to the board members, a challenge for cause to the board's legal advisor that were overlooked or ignored. If there was evidence that the respondent, that's you, the person who is responding to the notice of misconduct, if you tried to put in evidence, but the board recorder objected and the legal advisor didn't allow it in, that's also a legal error. If you objected to certain evidence, but it was considered over your objection, that also could amount to a legal error that needs to be highlighted in that Memorandum of Deficiencies. We also address in a Memorandum of Deficiencies, in addition to those legal errors, whether or not there's any matter for which we should just look at equity. Did you already have a medical board in play? Are you now asking that the show cause authority disapprove a separation for misconduct and instead take door number 2, which is that medical separation, to be able to approve that instead of the misconduct? That affects greatly all of the potential benefits that you would have to gain by virtue of an honorable separation. There is an opportunity still to be persuasive. And even if that show cause authority wants to ignore this Memorandum of Deficiencies, I promise you this is the first document that PERS or HRC, depending on your branch equivalent, is going to take a look at. Because if your show cause authority is only a stepping stone, and if it has to be approved, and there's several different iterations of when that needs to be, particularly if you have already vested a great number of years in, if that needs to go up to that next higher authority for approval before your separation can be approved, then this is the first document that they're going to be looked at. Oftentimes we see when there are substantial deviations from the rules, whether in legal error or procedure or otherwise, we see these boards get vacated and kicked back for another bite at the apple. And it can't get any worse for you, so you better put your best face forward, and you better find advocates who know what they're doing, who've been doing this for decades. That's who we are. Contact us soon. Make sure you like and subscribe. Find us as the Messy Military Lawyer, UCMJ Defender, Jocelyn Stewart.